So the remote work challenge is in that control versus independence. And you're probably asking yourself now, how much autonomy can I give them? How much should I give them? You still have to look at the Department of Labor. And when I say Department of Labor, we're talking not just the U.S. Department of Labor, but we're talking about the Department of Labor in every state where you may have a remote worker. If you're willfully misclassifying a remote employee as a contractor to avoid paying taxes or securing mandatory insurance, that could be viewed as deceptive or fraudulent.
Welcome and thank you all for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Nancy L. Schick. Nancy L. Schick, Esquire, is an award-winning attorney, author, and conflict resolution professional dedicated to helping licensed professionals manage critical risks in employment and leadership practices. As founder of Third Ear Conflict Resolution, Nancy has advised lawyers, funeral directors, medical providers, and social workers on mitigating complex legal, financial, and ethical liabilities associated with managing both traditional and remote workforces. The webinar presentation that you're about to watch will be approximately 1 hour, and Nancy will be taking questions from the audience, time permitting. So if you have questions that you'd like us to get to at the end of the presentation, you can always submit those by clicking into the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Nancy to discuss risk and responsibility in remote employment, a legal perspective.
Good afternoon. So I don't think we need to go into too much about who I am at this point. So we'll just keep going. And it looks like we're having a little trouble with slides, so I apologize. There we go. So what we're going to cover today are things like worker classification in a remote environment. Although most of us, I think at this point, especially if we still have remote workers, have some idea of how to navigate things like Zoom. Obviously, you know Zoom, you're here, you know that you need to be thinking about cybersecurity and various policies around that. I'm not covering that today. It's really because this worker classification issue keeps showing up that we thought this would be a very important webinar for you today. We're going to cover some things like financial and contractual risks. As lawyers, we don't always get that business training, and we don't always think about how the business and the employment issues come together. We'll touch on a little bit of wage and hour, and for those of you that are in New York, you're aware of FIFA. We'll cover that. And for those of you who aren't in New York, you'll learn about the Freelance Isn't Free Act if you're not familiar with it, because other states are looking at that to implement something similar. And you may already have that either in your state or in your locality. It started here in New York with New York City and then expanded into the state. So it is very possible for those of you that are in states with large metropolitan areas that you're already dealing with some variation of that law. And of course, we'll talk about the ethical implications and some risk management. So this is probably a little bit more for those of you that are in a management capacity in your law firm, but as we know, we all have those ethical responsibilities no matter who is giving the direction and who has the ultimate authority in our firms. We still have the same ethical responsibilities. So that's where we cover them so that you can recognize when maybe your firm isn't doing things in full compliance, then you know how to raise the issue in a powerful way. By the end of this hour today, what my goal is for you to be able to identify the classification distinctions for remote and virtual workers. You're going to hear that they're not that different, and that's why we're covering this. I want you to be able to assess some of the financial costs and the compliance risks, right? Being able to balance the cost and the benefit. For those of you that maybe aren't in a management role or aren't in a financial decision-making role, it's still important for you to understand how these decisions are made, because ideally you will be either running your firm someday by being a partner in your firm, or maybe being, like me, a solo. I want you to be able to apply those best practices for managing remote freelancers. And you'll notice that I'm saying freelancer and worker. Sometimes that ideally will come together for you also, why I'm making those distinctions. It's very, very important that you're not calling, for example, people 1099 employees or anything like that. That does not exist as a legal category. And I still hear even lawyers make that mistake. And then the last thing I want you to be able to do is to think through some of the ethical implications of non-compliant remote employment practices. And you'll hear some of the horror stories that I've dealt with where attorneys didn't necessarily do it willfully, but found themselves in a little bit of hot water, potentially with their disciplinary committees, because of some decisions that they made related to employment, not just in the law firm, but in their private lives, either with side businesses or domestic employment. So let's talk about first this worker classification in remote work. The big challenge that we run into is substance over form. The details of the work of your and your relationship with the worker are more important than the contract terms. That should not come as a surprise for most of you, but again, I still find that there is this gray area that maybe because we're lawyers, some of us are more willing to take risks and some of us are highly protective and and are much more afraid to take the risks, and it gets confusing. We all know that if this were as cut and dry as we would like, there probably wouldn't be lawyers doing this particular work. So aside from worrying about your worker being like this lazy cat taking a nap on the job, you still need to be concerned about the substance of the relationship. So the remote work challenge is in that control versus independence, because your remote workers have a lot of autonomy. And you're probably asking yourself now, like most people are, is how much do I need to bring workers back to the office? How much autonomy can I give them? How much should I give them? And then you're asking the same questions about your independent contractors. So those distinctions are very important, because that control that you exercise, including over an independent contractor, could make them an employee in the eyes of various government agencies. Yeah. Again, most of this probably is not going to come as a surprise, but maybe if you've been practicing for a long time and the laws have changed and maybe you don't practice employment law, this could be some news for you, is that your freedom to contract is pretty limited in all 50 states when it comes to employment contracts. And that does in some ways also cover independent contractor agreements. And we'll talk about why those are not automatically honored. And it's because, bottom line, is the various government agencies, right, have to protect the worker. That's why they're there. There's a presumption that you, as lawyers, especially if you're running your own law firm, should know the law, right? And then just like with any other business, you have basically a privilege to run a law firm or to run a business. So you're automatically presumed to be here where your employee might be here. So anytime that you're dealing with that, remember that you are presumed to have more knowledge, to have made more decisions that are opting to run a business, and therefore you're assuming a lot of the risk. And in exchange for the privilege of doing business, you also have certain agreements to make sure that your employees are protected. So keep that all in the back of your mind as you're thinking through these relationships with the various workers that support your business. So the first one that we often hear is, of course, the IRS common law test. And because that's the one that your accountant is usually talking to you about. And again, if I'm talking to any of you who are employment lawyers, this is probably a review for you, but it gives you maybe an opportunity to have a different conversation with some of your clients about why we do what we do. So this should still provide value even to those of you who are engaged in this on a regular basis. The IRS common law test starts with behavioral. Does the company, or in this case, the law firm, control what the worker does, how they do it? That means you're probably exercising a lot of control. And again, the more control that you exercise, the more likely your worker is going to be deemed an employee. If you think about how a vendor typically works, that's truly independent, they're running their own independent business. They're taking on the risks of running that business. They have, like I said with you, you're up here presumed to have a certain degree of knowledge. They're supposed to be on equal footing. If you have to train the worker, tell them how to do the job, tell them what equipment and supplies to use, mandate certain software, tell them what time to come to work, what time to leave work, you're providing even a secure laptop for them to do that work, then it starts to look a lot more like you don't have the independent business owner that you've hired. And that's one of the things that the IRS looks very closely at. The second thing that they'll look at is the financial aspects. Are business aspects controlled by the payer, in this case, you, the law firm? Do you determine when that check gets cut? Or is there a contract that says, I will send you an invoice and you will pay me within 30 days, or it's immediately upon receipt? Is it you pay a deposit up front and that was a decision made by your vendor or contractor? I want you thinking about vendors and contractors as basically the same, and that includes freelancers, independent contractors. I've heard things like permalancer, lots of different fancy terms for the same type of worker, but you're listening for, are they truly independent business owners with at least the opportunity for multiple contracts providing the same services that they're providing you? That is usually a pretty good assessment of someone who is truly independent. They have a website, they have business cards, brochures, they hold themselves out as independent businesses. That's what they're looking for in these government agencies. And then the other thing that they're looking for to determine if this meets the common law test is the type of relationship. Was there a written contract? Again, for those of you in New York, you should already be familiar with FIFA and the requirement of having a written contract. I recommend that you have one, even if you're not in New York, when you're working with an independent contractor, with a vendor. And usually the vendor is going to give you the contract and you're going to negotiate terms because you're on equal footing. But if you start doing things like having a written contract and you include employee-like benefits, even for your remote workers, and you're exercising a lot of control, it starts to look a lot more like employment. So say, for example, you have a written contract and it's called at the top, right? I see this all the time. It says independent contractor agreement. That alone does not protect you because we're back to substance over form. What does that written contract say? You can have a scope of work that gives some guidance on what result you're trying to achieve, but ultimately the vendor should be the expert and you don't have to tell them how to do it. Likewise, they provide their own insurance, their own benefits. I see a lot of penalties that I negotiate with various government agencies for misclassifying workers, and those employers have had an independent contractor agreement. They've had these remote workers. They'll say, "Oh, they don't work in my office. They use their own computers from home," and that may not be enough to sever the relationship. And then the employers or the businesses, the law firms, they may include things like health insurance rate. The independent contractor is looking for a good rate. Maybe it's hard for them to get health insurance, and you think as the client, "Hey, here's a great opportunity for us to negotiate on price. I'll put you on our health insurance, or I can help you with other employee-like benefits. I'm gonna give you paid vacation." I've literally seen all of these things, and you can probably hear it, that sounds a lot more like an employment relationship, and that may even fail the IRS common law test. Now, that's not going to be enough. Even if you get through the IRS common law test, you still have to look at the Department of Labor. And when I say Department of Labor, we're talking not just the US Department of Labor, but we're talking about the Department of Labor in every state where you may have a remote worker. You need to be doing this analysis because the states are very different in how they navigate the employment relationship. And again, thinking about you are held to this higher standard, not just as a lawyer, but as a business owner who has opted to run a business. You need to be making sure that you're looking through all of these different criteria and ensuring that you've tightened up everywhere that you can. It's not going to ever be 100%. I know I'm talking to lawyers, so you already know that, but you definitely wanna get as close to perfect as possible because I definitely do a lot of penalties every year, and as I mentioned earlier, we see it in wage and hour and other types of benefits where there can be penalties, and then there may be the FIFA or a freelance isn't free act like law that might also apply in your state or locality. So under the Department of Labor Economic Realities Test, it's similar to what we've talked about with the IRS. We're looking at is the service that your worker is providing an integral part of your business? Is it part of the core function? So obviously a virtual paralegal for a law firm. Most law firms, if you have paralegals, it's essential to your job. It's an it's a core function. It's integral to the business. But a distinction might be you have a social media contractor who has a lot of other social media clients. Not necessarily integral. You could still have a law firm without a social media manager. So that's part of what we're looking at here. Virtual assistants for administrative tasks, depending on the types of tasks that they're doing, may or may not fall into that integral part. And where I'm seeing a lot more of this, and we're anticipating even more, is with the virtual assistant who performs a variety of functions. So they might be doing your social media, which could be carved out, but they're also doing things like checking your email, scheduling appointments with potential clients. Again, it starts to sound a lot more like something that's integral to your business. So you might not pass that test. Then we look at the permanency of the relationship. Is this a long-term continuous remote engagement where they're coming in and doing a certain number of hours every week? We see that a lot with virtual assistants that do administrative work, like you said, with email, scheduling, maybe making travel arrangements for you. They could be doing some market research for you, and that gets a little gray as well. If they're doing market research and then setting up appointments with potential clients, then that could also come into a more permanent type relationship that looks integral to the business. And these are subjective inquiries that the government agencies have a lot of latitude to determine on their own. So that's another reason that I want you thinking these things through, is how do you minimize the likelihood of argument on these points, right? Just like you would do for your clients, you want to tighten up everywhere you can in a contract and in a relationship. You want to make sure you're doing this for yourself as well. And look, we've all been guilty, myself included, where we're the cobblers with no shoes, right? So that's why we're doing this as well. Next, you want to look at the investment that the worker had in their own facilities, their own equipment, or did you provide all of that? The more that you're providing, again, the economic realities are that you are investing enough in this worker that they look like they're probably your employee. To distinguish, it might be that your worker has their own computer, they have their own insurance, they have cybersecurity insurance, they've gotten a business license, they've done a lot to protect their personal assets from the operations of a business. That would look a lot more like a true vendor, a true independent contractor, a true freelancer, not an employee. And then you want to look at control. What is the nature and degree of the control? If, again, you're having even a weekly meeting with your quote vendor or freelancer, independent contractor, that doesn't look like a contractor. And another analogy that I often use with my clients is to think about if you were building a house. You might hire a general contractor, they would then sub out certain things, but you don't tell them how to do it, right? You're not telling the plumber how to install pipes. You're not telling the electrician how to do wiring. The more that you're doing that, the more you're controlling it, the more that you're the expert and they're your employee. And then we start getting into yet another test that you want to make sure that your independent contractors can pass, is this state-specific ABC test. It's not the same in every state, so you'll need to check in every state where you have workers working remotely. I see this a lot since the pandemic, where your worker may have started in New York or wherever else you might be located. And then because they could work remotely, they moved closer to their families and are working from Ohio, and you're based in New York, but they're still skilled and you're still having them work. So you need to then look at Ohio if that worker moved. It's no longer just New York. So you're going to need to also find out, do you have an ABC test in the state where your worker is located and where they're doing the majority of their work? And can you pass it? Same thing, you're going to see that they're looking for autonomy. Are they free from your control and direction? And it's a distinction between the result that you're looking for and the process that is used. It doesn't mean you can't say, look, our clients have certain requirements, or as a law firm, obviously we have certain requirements and certain ethical requirements, but ultimately you tell them what you need and they tell you how to do it. Hopefully you're screening your independent contractors enough that you know that they understand things like the ethical obligations that you have, confidentiality. They're looking at things like cybersecurity and protecting your data. If not, you might want to consider working with someone else, but it's ultimately to give them more autonomy. And as a quick aside, the more autonomy that you're giving, even your employees, you'll often find that they produce better. But there's this balance that needs to be struck. Still looking at, are they truly independent? You're looking at the business scope. Is it outside of the usual course of your business? Is it integral, is what the inquiry would be from the IRS. Then is the worker customarily engaged in this particular trade, or this providing those services that they're providing to you, are they also providing them to the general public or to others similarly situated? So other law firms, are they doing it for other professional services firms or just other businesses generally? It's, are they truly a business? And that's why I came up with that little rule of, is it a truly independent business with at least the potential for multiple contracts, right? Independent contractor. And then if they are, because they're holding themselves out as a business, it starts to look a lot more like you can pass that ABC test. Now, again, for a virtual paralegal, that would fail the B test for a law firm because it is integral to your business. Now, New York has one of the lengthiest, I think, worker misclassification tests, and we see this a lot in my state and in my practice, that it starts with the Construction Industry Fair Play Act, and although that obviously doesn't apply to a law firm, it is a great guide for looking at, again, free from direction and control, not subject to cancellation when the contract ends. That is another thing that we can look at, is the timing of the relationship. Has the outside firm made that substantial investment? And going back to how we look at it in the construction industry, you can probably hear it, as we all know that lots of firms will open an LLC, right, just to get through a contract, and then as soon as that contract is over, they close the LLC. Hopefully, you're not doing something like that with an administrative person or any of your vendors, but that's what happens in construction, so they would be looking for something like that, including in a law firm. You wanna look at things like the profits and losses, who bears that, who benefits from it, are those services available to the general public, how are federal income taxes filed, or state income taxes for that matter, do they perform under their own name? And a big red flag for me when I'm doing various audits or when I'm negotiating penalty resolution is I look for how the services were paid for. Was the invoice from an individual, and was the 1099 issued with a Social Security number on it, or was there an entity name? You might still have someone who's a DBA that you're using their social, but they have a formal DBA where they've gone and filed for this assumed name for the business purpose. That's a little easier for me to argue. Same thing if they have a license or permit in their name. They have those tools and equipment that are theirs. They hire their own employees, and they have the right to perform similar services for others. You hear that one? And so I do still see the non-compete agreements that come up, and they can sometimes then cancel out any argument that the worker was independent. It doesn't mean it's necessarily going to go that way, but I definitely see if a lot of the other factors are gray enough that having that limitation will sometimes cancel out the argument for an independent contractor relationship. And it really just depends on how business savvy they think the individuals are versus you as the law firm and the hiring business. And then the contractor does not represent, this is a big one as well, that the contractor does not represent the entity, so you as the law firm or the hiring firm. For example, if they're given business cards with your law firm name on it, and then you're still calling them a contractor, that's probably not gonna fly with definitely not with New York and most government agencies at this point. So you don't want to have them using your signature, your email, and anything that might make it difficult for the general public to see that one is a contractor and one is an employee. If they're representing you and they look to the general public like they're part of your law firm, they are probably going to be your employees. So, which state test applies? It's usually, again, the worker's state of residence. And now's the time for you to check your knowledge, and it also gives you a chance to confirm your participation. So there is a question on the screen, but we'll go through this first. Where a small law firm, let's assume it's a small law firm like mine, hires a virtual paralegal through Upwork or one of those online platforms that matches. Like there's Fiverr and a whole bunch of those other ones that match independent workers to various business that want to hire them. And it's like, I just need some help managing all this overflow work. And I need it between the hours of 8 and 5, Monday through Friday. The firm then provides this worker with a secure laptop, again, trying to address the confidentiality issues and the cybersecurity issues, provides a detailed instruction sheet with all the deadlines for all assignments, and then he's paid hourly based on a timesheet that's submitted through Gusto, which is the firm's payroll provider. Sometimes there's no overflow work, so there are no hours to report. So what do you think? Is this an employee or an independent contractor? Okay. So, and I see that we have quite a few of you that say, yes, this is an employee. And it's probably, as others of you said, it depends. And it depends on probably what state that worker is in. I do see that we have, over the years, been fortunate with the arguments with the government if the worker is, for example, out of the country. Then obviously the state government wouldn't have jurisdiction, right? It's even hard for the federal government to get jurisdiction, but we are seeing that change as well. What can happen, it's difficult to get that very long-arm jurisdiction in some of the countries where you might be hiring the independent workers, but we are seeing different countries even try to protect their workers to make sure that you're not circumventing their laws. So even when you think you're unable to have jurisdiction gained over you, and so you're just going to go forward, be aware that you may still have some countries try to exercise jurisdiction, so don't go there. If, for example, you have a worker in the Philippines and you're challenging the independent contractor relationship, I wouldn't take a vacation there when you have that working, because we are seeing, again, more attempts to get that long-arm jurisdiction to protect workers from exploitation. And that's really what they're most concerned about. Are you providing the various benefits? Are you paying them a living wage? Are you abiding by the laws where they're located? Not where you're located, but where they are located. So in this case, I would say there is pretty high likelihood that this is an employee. The mandated hours of 8 to 5 and detailed instructions hit that behavioral criteria. The financial is they're paid through the firm's payroll company, not via invoice. So that also looks like an employee. And then they're provided that key tool, right, for a paralegal is that secure laptop. That looks a lot like what you would do for an employee. Now, there are two things that might work for you in your favor, depending on what state you're in. They're sourced through Upwork, not necessarily, you didn't put a job post out on one of these many job boards. I won't name them because there are just so many. And sometimes there's no work, so it's not as regular, and that does look like there is some financial risk for the contractor, but I would still say err on the side of caution. Either make this person an independent contractor or maybe look somewhere else for someone with that has a separate business and falls into more of the categories that would show they're truly independent businesses. I think if you're in New York, you're probably going to lose on this one. This one would probably be an employee. The high degree of control likely makes him an employee despite the remote work and the gig platform context. Let's talk about then the financial and contractual risks in a remote workforce. It's the wage and hour violations, right? That could be back pay for minimum wage and overtime. There could be treble damages for that. And if you've had problems with this before, it could get even worse for you. There are some states and cities that have paid sick leave. New York is one of them. They have paid safe and sick leave, and that is even expanding for those of you in New York, and you're not aware of that. The Earned Safe and Sick Time Act is expanding on February 22nd, so you will be required to front load 32 hours of unpaid leave. And then that will be a front load every year after that. And they still would accrue their paid leave as well. So be aware, we could do a whole webinar on that alone, but be aware that that's there. And so if you have misclassified, you've also then broken the Safe and Sick Leave Act by not providing, right? Because you see, again, if you're calling them independent, but you're paying them sick leave, you've muddied the waters. It means they're probably going to be deemed your employee. So it's much better to do that thorough analysis and just, I would say, err on the side of employment unless you're working with a truly separate business that has a tax identification number or an employer identification number, has a DBA, has a lot of filings, maybe has their own insurance. Otherwise, you run a lot of risk with various penalties. And again, for New York also, not just the paid safe and sick leave, but you also now have paid prenatal leave that took effect last year, which for pregnant employees, you have 20 hours of paid leave for paid prenatal leave on top of all the sick and vacation and anything else you might be providing. If you've misclassified a worker, you haven't been providing that, you again run the risk of additional penalties plus the back pay for minimum wage and overtime potentially, and it starts to add up very quickly. So everything you think you saved might get wiped out very quickly. And that's where then mandatory insurance comes in. With your paid family leave, it's covered with your disability policy in New York that's required. You also have, of course, workers' compensation. And if you have misclassified and you're not providing workers' compensation, if you're a small firm that doesn't have any workers' compensation because you're a solo, and they now find that your independent contractor is your employee, you don't have workers' comp, it's $2,000 for every 10-day period for each worker for not having that insurance. Usually by the time those get to me, there's a minimum penalty of $16,000. Doesn't mean I can't negotiate to get those resolved, but it's definitely terrifying when you get 16,000 or more. I've seen them as high as $500,000, including on a small virtual law firm or virtual business. And it's terrifying to get that and recognize that you may have broken a law and that could attach your law license. So again, where the employee works is controlling, not where you, the firm, is located. And that includes potentially some of the offshore workers. And it's because we're concerned about this issue. It's not just the taxes, but it is we don't want workers to be exploited and then have no way of getting some sort of workers' compensation benefit if they get injured, disability, paid family leave, all of the things that the legislatures have passed to protect workers. If you're trying to circumvent them, there has been a rise of freelancer protection laws, such as New York State's Freelance Isn't Free Act. And not surprisingly, this came out of a lot of employers doing things like firing an entire department and then bringing a lot of them back as independent contractors, giving them a written contract, trying to basically say, you're now independent and therefore I don't have to pay all these extra benefits. So New York they got wise to it, right? They said, wait a minute. So now if you're paying someone for more than $800 of work in a year, you need to outline the scope, compensation, the payment schedule. And they do have, for those of you in New York, they do have a model contract that you could use that's pretty straightforward, but you need to outline it. I don't love this law. I've been pretty vocal about that because I think it muddies the water even more. But know that you need to have that written agreement and make sure that it's clear. Typically, again, the reason I don't like the law is because usually your vendor's going to be the one that's the expert and tells you, here's the contract, here's how it's going to go, here's what I need from you because I'm the one that's done it. Doesn't matter in New York under the Freelance Isn't Free Act. If your vendor isn't providing it, then you better do it. Then it requires timely payment. Again, another reason that we have this is because a lot of contractors were not getting paid and they were left to go to court and fight bigger companies to get paid for the work that they did. So the Freelance Isn't Free Act gives them a little bit of a fast track to recover their contractual earnings. And it does also provide them with retaliation protection. So you cannot penalize a freelancer for asserting their rights. Now, here's the unfun part for those of us that are attorneys. There are no protections for us under FIFA. We are excluded specifically from this because we're presumed to have the business savvy and the legal savvy to protect ourselves. Not always true that we don't always do it. Again, we can sometimes be those cobblers with no shoes, but we are accepted from this. So are licensed medical professionals, certain sales representatives, and construction contractors. We're really looking at more service-based businesses, such as your web developer, your social media person, your virtual assistant who's doing administrative work. So let's do another little check-in here. Are freelance legal services free? In this case, a defense firm hired a well-known trial attorney, and he said, okay, I need you to litigate this high-profile case. They agreed in the email that the attorney would be paid a flat fee for every day that they were at trial. So they said $1,000 every day you're at trial. The case settled on the second day of trial, and the defense firm's client disputed the bill. And that caused a 60-day delay in payment to the trial attorney. Could the trial attorney file a FIFA complaint and collect the $4,000? What do you think? This is where we're testing you to see if you're still awake. I know it's a holiday, but we want to make sure that you're getting something out of this. So the quick answer is, okay, so you said yes, some of you. And oops, sorry, get another cup of coffee. I know it's late in the day, but get one anyway, because again, the trial attorney is accepted from the Freelance Isn't Free Act complaint. So you would not be able to file. Attorneys and other professionals, such as medical professionals, are exempted from coverage under FIFA. Now, The exception might be is, let's say the attorney was not a trial attorney. Maybe it was an attorney who has a side gig providing web development or app development, some sort of AI prompting. They help businesses set up in other ways. Well, that might be different because now they're not acting in their capacity as an attorney. They're acting in a capacity as an unlicensed professional. And they might fall into some FIFA protection in that particular situation. But if you're providing legal services, basically the state of New York says, too bad, so sad, you should know how to protect yourself. So what costs of noncompliance are there in addition? Then this is still under FIFA. It's double damages. So let's say that attorney was, again, providing something like a website design and was charging $4,000 for the website. They might be able to get $8,000 back from you because they would suddenly be under FIFA. They could also recover attorney's fees and fines, and they could cause your firm a lot of reputational harm. So it's good to be thinking about, how do you have powerful relationships? I'm a mediator, so of course I'm going to go to that particular aspect of the relationship. It's usually just a best practice to make sure you know what your current processes are, align them with some of the things all of the things I've talked about, not just some of them, all of the things that I've talked about today. Make sure you're using compliant contract templates. Even if you're outside of New York, you might go and look at the model contract we use under FIFA just to make sure that you're including all of the appropriate terms in your contracts. Some of us haven't touched very many contracts and aren't drafting them on a daily basis, the way that we did when we studied contracts in that first year of law school. So it's not a bad idea to periodically see what other people are doing. And I'm a big fan of, if your state is giving you a model contract, at least take a look at it and make sure that you've got those provisions in it. You want to make sure that you're training any staff members who hire or manage freelancers to assess whether they're truly independent contractors. And do you remember what I said about one of the big things that I look for? It's a 1099 with a social security number on it. That's not 100% a deal breaker with a relationship, and it doesn't automatically mean you're going to be penalized, but it makes it a lot harder to argue that that person is truly an independent business if you're using their social and you're paying them pretty much like you pay any other employee. And the other thing to think about is there's a lot of great technology out there for contract management, and that may be something else that you implement in the coming year, is some sort of technology to help you navigate some of these remote and independent contractor relationships, especially if you're working with a variety of people in various states and localities. Make the technology work for you. I know that that adds another complexity, but it can be done. And one of the reasons we do this is we're going to look at some ethical implications as well as the risk management, and it's to keep you out of the disciplinary committee's office, right? You're held to the higher standard. You have a duty to uphold the law. You took an oath. So you're obviously going to be held to those higher standards of conduct, whether you're in the office, in court, or anywhere else. And any noncompliance with employment laws, even for remote workers, it erodes public trust in the legal system. And that's why they are looking at this a little bit more than they might have in the past. And some of the rules that you need to be thinking about are, it may, depending again which state you're in, you might not be an ABA model rules jurisdiction, but you might be New York and have your own ethical rules, but you still can look at the model rules and get something out of this part of the conversation, because you're more than likely going to have something very similar in your state, even if the rule is slightly different. Right? We know we're not supposed to conduct any of our business involving dishonesty, fraud, deceit, or misrepresentation. So you have to be thinking about that. is, have you done your due diligence to make sure that you're not taking advantage of a worker? If you're willfully misclassifying a remote employee as a contractor to avoid paying taxes or securing mandatory insurance, that could be viewed as deceptive or fraudulent. And if you've done it more than once, you could possibly lose your license, at least temporarily. Model Rule 5.6, right? That's limiting your ability to restrict an I'm sorry, it limits a firm's ability to restrict an attorney from practicing law. Remember, this is where we talked earlier about the non-competes. So it's long been a practice, I think, to just remember that if you have an attorney that leaves, they can't solicit, and that's different from non-competition. But if your clients follow an attorney who leaves because you weren't serving them the same way, we usually just say, focus somewhere else and move on, right? Let that go. Don't try to restrict them with a non-compete. A lot of states are not going to uphold those non-competes anyway. Then when structuring agreements with remote attorneys and departing attorneys, remember these things, that let the clients go where they need to go. Keep them happy before they leave you. That's the better thing to do. So in this situation, here's a colleague that very busy government attorney hires a live-in nanny because they're about to have their first child, and the wife and the attorney, right, they're both pretty high profile, have demanding jobs, but they can also afford to have a nanny. So they say, hey, what a great idea. Let's hire a full-time nanny to help with the child. They go through all the arrangements. The wife, who's a non-attorney, made all the arrangements, negotiated the nanny's pay, managed her work schedule, managed her work. The nanny was really treated well, right? Worked fewer than 35 hours, was given a lot of time off, was paid a very high weekly rate, well beyond what would be minimum wage, and they were paid monthly. Then the attorney got a notice that they needed to also provide workers' compensation, disability, and paid family leave insurance. So in this particular situation, could the penalty lead to attorney discipline? What do you think? And it's my assessment of this is what a lot of you said. It yes or maybe is what most of you decided, and that would be mine as well. Even though this is a personal conduct, it does show a disregard for known legal obligations, which is, if you're hiring somebody to work for you, you better make sure that you know whether you're an employer or is this an independent contractor, because if you willfully disregard this, you could be subject to discipline. If you had known about the insurance requirements and intentionally avoided them, it could be considered dishonesty or deceit. So you want to make sure you're in compliance, right? These are your best practices. Make sure that you know what those guidelines are. Use checklists in your firm, but also if you're hiring full-time help, I see it with full-time nannies, full-time housekeepers, live-in aides, especially for those of us who have aging family members that we may be taking care of, and we're providing that full-time 24/7 care. That's where I see this show up a lot. We get very busy and we're not thinking through the things that we would do for our clients. So make sure you're doing that for whether you're hiring people at home or in your law firm or in an outside business that you might also be a partner in. You want to have regular compliance audits, just like you would advise your clients to do, and especially if you have remote workers in other states. Make sure that you have formal written agreements for all workers, whether it be employees, contractors, freelancers, especially if you have a mix of those types of workers, because if you have a mix of employees and contractors or freelancers, the more distinct you can make those relationships, the better. And, again, talking to lawyers here, having it in writing, it's not foolproof, but it is a lot better to lay that out. And what you'll find is that often makes it easier to manage your workforce as well. And then make sure that you're training your managers, whether it be your law firm manager or anyone else who might be managing in your law firm, including also if managing at home, if you have that full-time domestic employee. And you want to avoid that control creep, though, right? So if you're going to call somebody independent, then don't micromanage them. You're going to have to tell them what the results are. You can give them some guidance in a scope of work, but the more that you're controlling how it's done, when it's done, whose tools are being used, etc., the more it's what we call control creep, and that's probably going to then attach an employment relationship. And then think about this in terms of culture. Go beyond, right? I get it, especially for those of you who are litigators. I'm a reformed litigator as well, and we're trained to just accept that it might end up in a lawsuit, but you don't really want to do that. You've got much better ways to spend your time, money, and energy. So look at that and how you can create a culture that resolves conflicts before they go to court. And that also then will enhance your reputation, increase loyalty. There are so many statistics that support that. And it makes it a lot easier for you to just keep operating and focus without a penalty or a lawsuit or a discrimination claim or whatever else might come out of that. A FIFA claim in New York. So the risks are high. The misclassification of remote workers leads to wage and hour violations, penalties, and other liabilities. Again, don't spend your time, money, and energy there. Better to get it right the first time. I know most of us hire, especially the small firms we hire when we're already overwhelmed. Well, you're already overwhelmed, so take a few extra hours to make sure that you've laid this out really carefully so that you don't end up with a claim. Remember that substance is more important than form. So no matter how good your contract is, the government agencies still have a lot of discretion to say, we don't care about your agreement. We still think that that's an employee. Ethics apply everywhere. Management missteps by attorneys, whether it's in the firm, a side business, or at home, can actually have professional disciplinary consequences. So, thank you. That was the end of my presentation, but I am going to hang around and be happy to, I'll be happy to answer any of your questions. And there's obviously my contact information if you need anything.
Yes, thank you so much, Nancy. Um, we have a few questions already, but if you haven't submitted your Q&A and you'd like to submit a question, you can always do that by clicking the Q&A button and sending it in there. As you mentioned, we already have quite a few, so we'll go ahead and get started. This first question comes from an anonymous attendee. They ask, would a factor be whether the VA has other similarly situated attorneys to whom they provide services during the same period of time they provide services to you?
Yes, and it doesn't actually necessarily matter if it's the same period, but it definitely helps my arguments if I can show that they have a bunch of clients, right? That's what we want to think of, is that these are clients. Every attorney that they're serving is a client. Now, if all those attorneys are in the same law firm, the client's the law firm, starts to look a lot more like employment.
Thank you for that insight, Nancy. This next question comes from Cheryl. They ask, would the fact that the VA is foreign or overseas alter any of the considerations?
Yes, and hopefully you caught that it does give me a lot of opportunity to argue, and in the past, I have argued that they're out of the country, so they are out of your jurisdiction, and that's probably true. For example, if I'm arguing that in New York, then I'm gonna say, "New York, you don't have jurisdiction," and that's great. You're done with the New York at that point. New York's not going to argue with you. However, don't be surprised if wherever your offshore worker is, if their governmental agency doesn't come knocking. Again, it's very long arm jurisdiction in some of these, but we are seeing more countries reach out and try and protect their workers.
Thank you, Nancy. This next question comes from Eva. They ask, my company has a lot of remote workers now. I'm in California, but they are based in India, Ireland, Mexico. And my thought is they want to make paralegals contractors in the future. What do you think are the downs and ups for becoming an independent contractor? So pros and cons of actually becoming an independent contractor as someone in California with remote workers internationally.
So I will tell you that, first of all, you probably want to talk to a California attorney. I am not licensed in California, but what we typically will look at is the independence factor is the big part of independent contractor, right? People like being able to set their own schedule. They like being able to work anywhere in the world. But again, what we're finding is that as workers are moving about, that you could, for example, have someone who starts in Mexico and they go work in Ireland for a little while, and Ireland says, "Whoa, wait a minute, we want some of that tax money for the income that they earned while they were working here." So I think the independence sounds great, but there are a lot of other risks that come with either side of that worker classification. So I would definitely recommend that you work with a California attorney and then have them also look at each jurisdiction where you have a worker.
Awesome. Thank you, Nancy. And then this next question comes from another anonymous attendee. They ask, does this apply to part-time W-2 employees?
And I'm not sure what you mean exactly, and I realize it may have come up during the webinar at a particular time, but I would say the best way I can answer that at this stage is, yes, this applies to all workers, regardless of whether they're part-time or full-time. You need to do the same kinds of analyses. It doesn't matter how many hours someone is working. That's not what determines their classification, and I've had a lot of people argue with me over that, including mentors who were very well-meaning but come from the old world where that worked. It does not matter how many hours. It matters things like we talked about, the control, the type of work, the financial investment, etc.
Awesome. Thank you. And then our next question is, do other states have freelance acts that you know of other than New York?
I believe that some of them do. I honestly could not rattle off which ones do, but I've heard that there are either some that are in the works. I believe California may have something similar. It's very difficult to classify, I think, an independent contractor in California. And again, it comes down to probably if I were to separate which states you might want to prioritize, I would say prioritize any of the states that have a large metropolitan area where you have a lot of freelance workers. So what we're talking about is probably states that such as New York, Illinois, California, New Jersey, Connecticut, those that have, historically very protective laws for workers. Those are the ones I would prioritize, but I still say you gotta look at all of them.
Awesome. Thank you, Nancy. And then we have two more questions left. So this next one comes from Elizabeth. They asked, what about document review attorneys? Would that be considered providing admin work or a legal service? If they're 1099 employees and the company doesn't pay them, how do they enforce that?
Oh boy, there's a lot in that. Thank you, Elizabeth, for that question. So the first thing is that it doesn't really matter if they're document review attorneys, even though they're doing admin work, versus providing, quote, legal services. I would say that's still going to be integral to the firm, right, to the law business. So they're definitely going to look at that as something that's being done on a regular basis. And it's probably rare that it would be done in project work. It could be that it's project work and then done through a temporary agency, and then the temporary agency is the actual employer, but you need to find out if that's the relationship, and make sure that if you're using a temp agency for document review, that you're having that conversation. So thank you for that question, Elizabeth, because that does raise the particular issue of, if I'm using an outside agency, do I need to be finding out how they classify the workers? And the answer is yes, including a virtual assistant agency or a document review agency. The second thing in that in your questions is the 1099 employee. There is no such thing as a 1099 employee, right? What you're doing in that situation is you're mixing 1099 contractor with employee. If they're getting a 1099, the business is claiming that the worker is an independent contractor. If they're calling them a 1099 employee, I'm going to assume that the government will agree with me here that they're probably just going to hear employee, and you better be providing all the other benefits of an employment situation. And then the final part of that question is, if the company doesn't pay them, how do they enforce that? And it would not be under FIFA, including in New York, right? You'd have to go to small claims court, probably, depending on what the level. I'm going to assume they're not withholding the pay for so long that they're going to go beyond small claims, but you might have to go to small claims court to enforce the agreement to get paid. Now, if you can show employment, however, then you can just go and fight that possibly with the Department of Labor, depending on what your state is doing for attorneys. You can also, forgot about this one, don't forget that you may also have a process to enforce fees through your local organization for either your local court. We have, for example, a fee arbitration division in our courts for attorneys' fees that don't get paid in New York, and you might be able to do it that way, but it's definitely something that you should probably know at the beginning of a relationship to make sure that you're negotiating well, and that's just good for any worker to make sure that you're asserting your rights up front so that you don't get exploited by any kind of business, whether it's an employer or a client.
Wonderful. Thank you, Nancy, for answering all those questions. We had another one, but it kind of got answered with that response
Okay,
to
let's do it.
Elizabeth's. So we're all set. I want to thank you all so much for your questions. And thank you, Nancy, for responding to our questions. We always really appreciate that audience interaction. We want to thank you all so much for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro does give you that access to CLE credit opportunities for live and on-demand webinars just like this one, so you can stay informed and complete your CLE requirements. Pro members also get other benefits like an enhanced directory profile, the AI-powered Justia chat to help you connect with more leads, and $200 off of select Justia marketing solutions. You can explore all of those benefits and more at pro.justia.com. Thank you all so much for joining, and thank you again, Nancy, for your time. Have a wonderful rest of your day, everyone. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.